I see a couple. I'd like to ask elected officials to stand and be recognized for taking the time and to serve the communities in which you live. So could they please stand and be recognized? Jeff? All right, thank you. All right. Okay, so we are going to move into our program. This is a very timely topic, the newly enacted Minnesota Health Insurance Exchange. And this is something that certainly is not unique to Minnesota. We are seeing exchanges across the country. Most states have decided to just use the federally facilitated exchanges. 17 states, Minnesota having been one of them, have decided that we're going to do this ourselves. So if I were a betting person, which occasionally I like to, I would say that of those 17 states that have said they're going to enact their own exchanges, they will not be all ready on October 1st. Actually, I think the minority of them will be ready. It's a significant, not to put the policy aside, the technological lift to get this done, and I'm sure we'll hear more about that, is incredible. But there's also incredibly important decisions to be made for small employers. Starting out the exchanges for small employers in 2016, that will go up to employers up to 100. And so we have with us today two experts who can really help everybody have a better understanding of what employers need to know and to answer the questions. We have two experts from Lockridge Grindle Nowen who are going to tackle this topic for us today. We also have put note cards on your table, so please, both of them are going to come up. We're going to have a presentation, but as you have questions, please write those down on the note card. We'll collect those, and then we'll leave plenty of time to have that discussion afterwards as well. So let me first introduce Susan Ellingstad. Susan Ellingstad heads the firm's employment law department and represents large and small governmental and business clients in federal, state, and administrative employment actions in Minnesota and throughout the country. Ms. Ellingstad specializes in litigation involving employment discrimination, harassment, wage and hour violations, and non-compete agreements. She also practices in the area of class action and commercial litigation. In addition to litigation, Ms. Ellingstad frequently writes and lectures on the Fair Labor Standards Act and other employment law issues, conducts training seminars for businesses, and counsels employers in the area of FLSA compliance, performance management, and disability accommodation issues. She also mediates employment law cases. We also have David Asp. David Asp practices primarily in the areas of commercial, healthcare, and employment litigation. He has particular experience with claims under the Employment Retirement Income Security Act, or ERISA, as well as healthcare fraud defense matters under Civil RICO and related claims. Mr. Asp also practices in the area of campaign finance and election law, advising political committees, candidates, and nonprofit organizations on compliance with state and federal campaign laws. He's also represented clients in matters before state agencies, the Federal Elections Commission, and the Minnesota Supreme Court. It's amazing they have time to be here. So thank you very much. So please join me in a warm TwinWest welcome for Susan and David.
Morning. Thank you so much for having us this morning. This topic is a very big one, the Affordable Care Act, and I'm guessing there's a lot of people in this room who know far more about the Act and the Minnesota exchanges than we do. So we're here to offer a perspective as lawyers and litigators, and as they said in the introduction, David and I do litigation primarily in the areas of employment litigation and healthcare litigation. An ERISA is a statute where there's causes of action involving benefits plans, and as you'll hear today as we talk through this, the Affordable Care Act has now been brought into ERISA, and the remedies under ERISA and the causes of action under ERISA are available to enforce rights under the Affordable Care Act. So we're looking at this act in terms of what are the risks of litigation that could come out of the mandates, the exchanges, and the changes in the healthcare law that are so big and just really unprecedented. So with that, and we'll get into the litigation in a few minutes, but we're going to give you kind of an overview as to the main components of the Affordable Care Act, the mandates that are going to trigger some claims, We're going to talk about the Minnesota Exchange that was just enacted this year, and then we're going to talk specifically about causes of action under the Affordable Care Act and ERISA that we think employers should be aware of, and claims that could already be developing as people get ready to comply with the law in 2014. So everyone knows what's already gone into effect under the Affordable Care Act. Certain provisions have been around now as far back as 2010. There's coverage of dependents to age 26. Pre-existing condition exclusions are prohibited. Preventative care is covered at 100%. No lifetime or annual limit on essential health benefits, which benefits are still in the process of being defined. There's new claims and appeals processes that have come along with the Affordable Care Act that have created a lot of new administrative review and challenges to those benefits. No reimbursement for over-the-counter medications. That's been around for a while. So what is coming now? This year, the exchanges, and we can talk about this at the end, the Minnesota Exchange is going to be up and running in October of 2013. Compliance with the new mandates goes into effect January 1st of 2014. And that means that for employers that are considered large employers, they need to provide coverage if they qualify as a large employer. So what everyone has heard of, the big question that's coming right now, that employers who fall in this 50-employee range, if you're kind of on that bubble of being a small to a large employer, everyone's heard the concept pay or play. And that's the analysis that is going on right now with employers of that size. If you're a large employer, that means you have 50 or more full-time equivalent employees. If you're a large employer, you have to provide coverage under the Affordable Care Act starting in 2014. The coverage that has to be provided has to be affordable and provides a minimum value of coverage, or you have to pay penalties. So the analysis that people are undergoing right now is weighing the play, providing benefits, providing coverage to their workforce, or paying the penalties. You can leave it on that side. So to determine a large employer, and this is kind of laying a backdrop because we're going to talk in a little bit about some of the risks in making this calculation. An employer has to determine whether they have 50 or more full-time equivalent. To do that, you look at your number of actual full-time employees, and then you have to look at the part-time employees and can take their hours into account. You add up all the part-time employees' hours in a month, divide it by 120, and that's how you get your full-time equivalent employees. Total that up with your full-time employees, and that's what you have. Now, a couple changes that are significant here in this definition is that the Affordable Care Act defines full-time as 30 or more hours a week. Most employers define part-time or full-time as 35 or more hours a week. So it is, I think, a change in the practices of a lot of employers to define full-time as 30 hours. So that's kind of a significant piece, and we'll talk in a minute what people are looking at with those hours. And then, as I said, you have to look at the part-time, add them up, and make that computation to determine whether you hit that 50-employee mark. So, for example, if you have 40 part-time employees working 15 hours per week, that's 5 full-time employees to be added in that computation to determine whether you hit the 50. Okay, so if you, that's to provide coverage. There's kind of 3 big components: whether you provide coverage, and then whether it's minimum value and affordable. Those are the mandates that are now being put into place. So if you have to provide coverage because you have 50 employees, you also have to have, the plan has to have minimum value, which means the plan pays at least 60% of the total cost of the benefit. And in addition to that, it has to be affordable, which means that the employee's contribution cannot exceed 9.5% of the employee's household income. So those are the mandates that employers have to have in place if they are a large employer. Okay. Now, I should say, when you're looking at this, the insurance brokers, this is something that this computation is out there. It's done. There's a pay-or-play calculator available. It's something that's pretty easy once you decide, if you're in that 50 range, to figure out this computation by weighing the penalties that would be imposed as opposed to the cost of the plan. And that's the calculation that a lot of employers in that range are making right now to decide whether they are going to participate and provide the benefits as opposed to pay the penalties. So the penalties that people should be aware of under the Affordable Care Act, if you do not offer the coverage, it's $2,000 excluding the first 30 employees. If at least one employee enrolls in the exchange and is receiving a subsidy for their premium or a reduction of the cost sharing. So you have to have at least one employee who goes outside, participates in the exchange, and gets that subsidy for the penalty to kick in. The other penalty that is less, I guess I see that less frequently in the materials out there, these are for large employers who decide to provide coverage. You still have to provide that affordable and meet that affordability and the minimum value pieces of the equation, or you can be penalized $3,000 for an employee who leaves the plan and goes on the exchange and receives a tax credit. Now, to get the tax credit or the subsidy on the exchange, the employee who chooses to leave a plan that's being offered to them, the employee has to show that that plan was not affordable in the first place. So it's not the case where you can offer a plan that meets all the requirements and have someone opt out of it and still be imposed the penalty. But if you meet the requirements with affordability and minimum value, then the subsidy should not be available to that employee who chooses to opt out, and then the penalty would not be imposed. Okay, so that's kind of the basics of the mandates and the penalties, and then we're going to talk briefly about the exchange and then come back to how these components could lead to claims.
Sure. So I'll talk a little bit about the exchange. And again, this is sort of by way of background because both of these areas, talking about the pay-or-play requirements, the requirements of large employers, and the exchange for smaller employers and individuals, lead to the discussion of risk and the risk for employers in determining whether they meet the large employer definition and then how they're going to exist with the exchange and the new mandates. So Minnesota's insurance exchange is called MNsure. That's the logo. And it's intended for small businesses and employees to purchase coverage. The legislature passed it in 2013. And as was alluded to in the question, it was controversial in its passage and contained a number of provisions that were hotly disputed. It's controlled by a 7-member board appointed by the governor, and that's what Senator Bonoff was referring to in terms of the conflict of interest rules. That was one of the areas that was hotly disputed, is who is allowed to serve on the board, what sort of affiliations can they have, and the legislation that ultimately passed and was signed by the governor prohibits those individuals with relationships with carriers from participating on the board. In addition, this is the second bullet point on this slide shows the active purchaser requirement, which will go into effect on 2015. That was the other point mentioned by Senator Bonoff, which essentially permits the Health Insurance Exchange Board to determine with some guidelines what sorts of products can be offered on the exchange. And so the concern here is that by allowing the board to limit the number instead of having what you'd refer to as a clearinghouse model. There'll be fewer products and less competition and less of a check on cost. On the flip side of that argument is the position that, well, we want to make sure that products offered on the exchange, where people are entering the exchange, offer a certain floor of benefits, and they offer a certain minimum protection for people who are purchasing insurance on the exchange. And so that's intended to be the role of that requirement. Doesn't go into effect right away. In the first year, it'll be the clearinghouse model, but then as of 2015, it remains to be seen what will happen with those plans, whether they'll remain on the exchange or whether they'll be limited.
Do you want to mention what Danette just told us before the...
Sure. If I can mention before we came up, Danette, who's an expert in exchanges, told us that in Washington State yesterday, the 8 plans who were going to be offered all pulled out of the exchange and couldn't be offered. So they're planning to have an exchange, but no one's going to show up to offer insurance.
Because of the active purchaser.
Because of the active purchaser restrictions. It just remains to be seen whether that will happen here or not. And it'll be an interesting development of the exchange to see how that requirement plays out. So how do businesses, and I should say how do consumers, navigate the Minnesota exchange? Within the last couple of weeks, there were new regulations issued regarding how the exchange will regulate people who sell products that can be offered on the exchange, and there are a whole host of them. And if I listed them all, it would be a giant chart with each of their names and the restrictions that they have and what they can offer. But you have navigators who work with the exchange. You have people called in-person assisters. You have insurance producers. They all have different roles, and sort of it's envisioned, at least by reading the regulations, that they'll all offer different services for different people or businesses looking for products on the exchange. So a navigator, for example, would be intended to provide information and educational, but at least according to the exchange, wouldn't replace the conventional role of an insurance broker. It's interesting that one of the things that you've seen in the discussion about the exchange is that a lot of employers feel very strongly about the relationships they have with their brokers. They want to protect and maintain that relationship, and of course the brokers have an interest in making sure that that they can continue to offer their services when their clients are looking for products on the exchange. The exchange also will offer the shop option, which permits defined contribution for purchasing health insurance. Defined contribution is an employer's option to give a particular sum of money and allow an employee to use that to purchase insurance. So essentially giving an employee the ability to become their own purchaser. One of the most frequent questions, and there's not at least a real clear answer all the time as to whether or not there are tax consequences for that. I think that the best answer is probably it depends on what sort of defined contribution model you're talking about. And generally speaking, it seems like the more of an ability that the employee has to make decisions, the less it looks like a benefit that's being provided by the employer, and that makes it more difficult to claim the deduction for the employer. So I think probably the take-home on that is that anyone looking at the defined contribution model and is concerned about the tax consequences with the deduction should very carefully seek out their accountant or tax attorney. So that brings us to litigation risks. With that background, what sorts of litigation risks should employers and businesses be looking at in thinking about the new mandates in the exchange?
Okay. The first thing that's right in the new law is its own whistleblower claim. And it's an amendment actually to the Fair Labor Standards Act that prohibits employers from discharging or in any manner discriminating against an employee with respect to their compensation terms, conditions of employment, and we like to say just that's adverse action, taking adverse employment action against anyone where the employee engages in protected conduct. The ACA defines protected conduct just like our own state statute, our whistleblower statute here, where you cannot be retaliated against for reporting a violation of law to the employer, the federal government, the state attorney general. You can't be retaliated against for testifying or participating in an investigation concerning a violation or objecting to an act that the employee reasonably believes to be a violation. So I think this is likely to be interpreted the same way that the normal whistleblower kinds of cases are interpreted, where if the employee has a good faith belief that there's a violation, it doesn't actually have to be a violation, but if they have a good faith, reasonable belief that there's a violation, for example, we'll get into this in a minute, but if they complain that I think you should be a covered employer and I think you're manipulating your hours or something to come in under 50 employees, that's a suspected belief of a violation, and then if that employee is adversely affected, they could have a claim for retaliation under the ACA. It also covers that you cannot take adverse action against someone who receives a credit, a tax credit, or a cost-sharing reduction under the ACA. For example, they go on the exchange and get a premium. They're the one employee who goes outside, gets that subsidy, and therefore subjects you to a penalty. That would be protected conduct under this statute. The way that this Affordable Care Act defines the whistleblower claim, it is designated OSHA as the administrative body to handle these kinds of complaints. You're probably all familiar, a lot of these will go to the EEOC or some other government agencies. OSHA is the designated administrative body here for an employee who believes that they've been retaliated against in violation of this whistleblower claim. And they have a fairly short time frame, however, to go and file a complaint with OSHA. And under that administrative process, OSHA then has to put out a preliminary order in making a determination on whether there's a valid basis for the claim. If they fail to issue a preliminary order, the employee can go to district court and file a claim just like any other employment type claim. But it is an administrative prerequisite that they go to OSHA first, just like a Title VII claim or a discrimination claim where the employee has to go to the EEOC first. There's a couple avenues that claim could take. It could stay in the administrative process, and either party could appeal from that order by OSHA and go before an administrative law judge, or it could go into district court. So that's a whole new cause of action and type of claim that could be brought and pursued in that setting. The damages are typical damages for employment claims. Reinstatement is a potential, back pay, that's a common damage for adverse employment action if you're terminated, and restoration of your benefits under the Affordable Care Act are all damages specifically authorized under the ACA. Now, the defenses to the retaliation claim are just like the defenses you would assert in any other kind of employment claim, that the adverse employment action that's taken against the employee was not because of either their participation in the exchange or their complaint of a violation. And so just like defending any other claim, you want to argue that there was a legitimate basis for that employment action that had nothing to do with the protected rights. One thing just to note, this type of claim that's now the whistleblower provisions under the ACA make the burden on the employers higher than it is in most cases. Usually the burden is on the plaintiff to show pretext. I don't know if you're familiar with that term. You show that the reason that's given by the employer is not true, it's false, and it's really a pretext for the violation. Here there's a different burden of proof that's written right into the statute, where the employee only has to show that the protected activity, the making of a complaint, was a contributing factor in the decision, and the employer has the burden to show by clear and convincing evidence that they would have, for example, terminated the employee anyway. So I found it interesting that the burden here with this clear and convincing evidence, and it's a higher burden on employers. So it's obviously, geared to be very protective legislation for the employee who might make a complaint under the whistleblower statute. You cannot arbitrate these claims, as a lot of employers are entering arbitration agreements on employment claims with their employees, where you are bound to go to arbitration, preventing them to go into court. That's not allowed for these types of claims. Okay, and then in addition to kind of that traditional whistleblower type of claim, we've been thinking about what other types of claims could be brought under ERISA that could to assert rights under the Affordable Care Act, and I think that's going to be a big area of litigation where people are exploring, and I can tell you right now there's plaintiffs' attorneys who are looking at this already and thinking, where are the vulnerabilities here to bring claims? And like I said at the beginning, the interesting part here is incorporating the ACA into ERISA. It's giving a private cause of action and remedies to this statute. And it also, I think what's going to be interesting to watch as the cases come, because these decisions that employers are making under the Affordable Care Act affect a broad base of employees and people who might be covered by a plan. I think it's particularly vulnerable to class action litigation, where instead of the single employee making a claim, people are going to look at it as a class of employees. So that's where we're kind of looking, and we're advising employers on how they go into this and with these mandates to avoid these possible claims. So.
Sure. It's just by way of background, so ERISA is the Employee Retirement Income Security Act. It's been around since the 70s, and the purpose of ERISA was to provide essentially procedural protections for employees who are making claims for benefits under plans that are sponsored by their employer. So there's not really, courts have always said there's not really a substantive requirement there in terms of no one's making you offer the benefit plan, but if you offer it, then there are a lot of particular procedures that you have to comply with. You have to provide particular administrative process, appeal rights. There are timing requirements on that. There are also requirements in terms of what you have to provide your employees when you deny a claim under the plan. And then there's procedures governing litigation, and in particular, there's ERISA provides for attorney fees. So it's an attractive vehicle for someone who's litigating on the plaintiff side, because there's an option to recover fees. In this context, as Susan mentioned, the procedural requirements of ERISA now apply alongside the substantive requirements of the Affordable Care Act. So the Affordable Care Act is requiring larger employers to provide the benefits, and then ERISA provides the vehicles for enforcing those rights once they've been provided. So where that's probably going to come into play is what's called an ERISA interference or discrimination claim, which essentially prohibits any adverse action against an employee that prevents them from attaining benefits under a plan to which they might become entitled. So that would be, in a classic sense, an employee would say, I was fired because you knew I was about to make a benefit claim, or you fired me so that I couldn't collect benefits. They would have this cause of action. Now it might apply to a circumstance where an employee would say, or say there's an employer who's in that sort of 50 to 60 employee range, and they're trying to decide what they can do to their workforce to not offer a benefit if they don't offer a plan right now. And if that employer decides to start terminating employees, for example, or doing some of the other things that Susan talked about earlier, changing employee status to independent contractor status, we can go through that. Yeah, but if you do those sorts of things, you could create the potential liability under ERISA. Oh, so that's actually the next slide. So reducing the workforce, as I just described, is potentially at least a claim under ERISA for interference with the participant's right. And so that would, the way you'd see it is if an employee was terminated, if an employer had, say, 52 or 53 employees, and the employer reduced its workforce to under 50, those employees would sue and say, you fired us so that you wouldn't have to provide the health benefit under the Affordable Care Act, and that violates ERISA.
And this question I think is really scary for employers, who we represent, because it seems really counterintuitive to tell an employer that you have lost control of your ability to modify your workforce. And I'm not saying that. I'm saying, but there's definitely risks with it right now, and I think we need to tread very carefully. But that, to me, is a very it's huge. And so a lot of employers, in fact, I've seen presentations and information about the Affordable Care Act that advise people, as you're planning this, modify your workforce. But can you do that? And so I think that's really, that's the big question that I think is really scary and seems like it just can't be the case almost, that you're frozen in time, you can't do things to your workforce, you can't decide, well, maybe I want to, not be subject to this. Do I have no option to, modify something? And we'll get into the different ways to do that. And I think that's, and we're not here to scare you or to, I'm certainly not giving advice that it can't be done, but I think flagging that as something to really think about and get advice on, because it's right now that can be looked at. And I think that's the other thing, that nothing's gone into effect yet. So to the extent anyone feels like, well, I'm going to take these actions and get ready, and nothing happens until 2014, but it's 2013 that's going to be looked at when you're measuring the size of the workplace. So if someone fires 7 people in 2013 and then 2014, you get a claim that, well, actually you tried to avoid, or deprive people, whatever the language is, deprive people of the attainment to their benefits that they might have been entitled to by doing that, 6 months ago. That's scary. And I think that's, so people need to be very careful right now what they're doing. And in addition to the 7 people who might have a claim, it's the 57 people who would be part of that large employer and get benefits if the employer hadn't reduced the workforce under 50. So, it's not, we're not talking massive class actions, but we are, for employers in that middle range, I think there's definitely claims, not just for the people who are specifically affected, but by anyone who then loses the right to participate in that plan. So I think the ways that that normally employ, and this, this is something people do as a business matter. You look at how do I reduce my full-time equivalents, and these are things people do every day. You reduce your workforce by terminating employees. One strategy could be to try to get out from under this is to terminate people and then go to a temp agency and use temps. That is done. Converting full-time to part-time is something that's certainly being contemplated as you look at the part-time and the full-time definitions. As I said at the beginning, part-time employees still get counted, so that's important to remember. They still get counted in the equation when you're measuring the 50. So it's not like, in fact, like seasonal employees, for example, don't get counted. If you have seasonal employees who are under 120 days a year, they're not part of that 50. But if you have part-time employees, you do have to add them up and divide and and factor that in. And then there's well, we consider part-time now 35. We're now going to, or whatever, we're going to do 29. So those are different ways that you could, as an employer, be either eliminating full-time workers or trying to reduce hours to get under that threshold. The other thing that I think we'll see people do is trying to classify employees as independent contractors. And that can be an absolutely legitimate way to have a worker as an independent contractor, but it's also something that is used all the time to reduce labor costs, and it needs to be looked at very, very carefully. There has already been a spike in litigation over misclassification of workers in the last several years because it's a huge source of revenue for states that they're missing out on tax revenue. And so it's already really, the independent contractor model is under scrutiny from departments of labor and the IRS already. And so if this is another avenue for people to try to get out of the Affordable Care Act, I think that we can expect scrutiny for employers who use independent contractors. And there's a Minnesota test, there's an IRS test, and it's pretty strict. It's pretty difficult to have a worker who's a legitimate independent contractor, and you have to meet a lot of criteria to do that. The main one is that you don't control the means and method of their work. And so, before taking that step, again, it's something you want to look at really carefully and make sure that they're legitimately an independent contractor and not just, that's a way to avoid that requirement. Okay. This is, I think, again, this is going to be something that's will probably be decided fairly soon after these mandates go into effect. It'll be litigated as to what our defense is here. Obviously, a defense is that you took these actions and it had nothing to do with depriving them of benefits or avoiding the pay or play. And the employee does have to show, under ERISA, you have to show specific intent to avoid the attainment of benefits. So, if there's legitimate reasons for doing it outside of this, you should be able to prevail in those cases because they won't be able to show specific intent. I think the other question, if you read the second bullet, this is very intellectually interesting to me, whether employers can defend this by saying, well, we didn't have an intent to deprive benefits, but we had an intent to avoid paying a tax. So, it is pay or play. You have the option of paying the penalty and not providing benefits. And so, it could be a defense possibly, that an employer could say, I opted not to pay the penalty, and it wasn't about depriving people of benefits. I don't know if that's going to fly or not, but I think we'll see that.
I'll just say, too, on that, it'll probably apply more. It's more likely to work with an employer who has some sort of policy or some sort of particular reason why they would never offer benefits in the first place. So if they said we could never offer a benefit to employees, therefore any action we took to get under that 50-employee threshold was simply to avoid a tax, not to do anything in particular to the employee.
And there's a lot of dispute out there in terms of, some people think this is not a risk. These cases are not going to be successful. So, and that you should have the ability essentially to do this, to do what you want with your workforce. So I guess the takeaway is it's untested yet until the statute comes into effect and there's case law, and so we should be very careful in making these decisions. You can talk about it.
Sure. Okay. And so, if the claim is successful, then what could the employee recover? And this is sort of always an interesting question under ERISA, because ERISA doesn't provide a claim for compensatory damages or punitive damages. It says that you can recover equitable relief. And that typically would mean something like reinstatement of the employee or reinstatement with potentially back pay, although the cases are disputed on that even. And so one of the defenses to any ERISA claim involves limiting the relief available to only equitable relief, which is more limited in scope. Now, on the flip side of that, as I mentioned earlier, ERISA also allows a prevailing party to recover attorney fees. So as part of any ERISA suit, you would see a claim for attorney fees, and if successful, they would probably be able to recover those attorney fees. So that's the sort of relief relief or damages that an employer would be looking at if found liable under that particular statute.
Okay. So those are, and I guess the whistleblower and the ERISA, those are the main things. There's other claims out there that we're not going to get into detail. There's an issue with the grandfathered plans and employers trying to assert a grandfathered status. I just wanted to flag that. I think it seems to me from reading this that it's going to be very, very difficult to claim grandfather status or to keep grandfather status. And so I think there's going to be litigation over employers who try to keep grandfather status. And that benefits because you don't have to pay 100% of preventative care and some other things. And so there may be reasons to try to do that. But again, doing that I think is going to be hotly contested and difficult and probably the subject of litigation. And probably fiduciary duty type claims, we'll see those too. So those are kind of the spectrum of things that I think are coming and coming soon. And you know, we're, as representing employers, we're trying to prepare and advise people to just be cautious as they go into 2014.
So thank you to both of you for that. We do want to have some questions. I'm going to start out with a question, but if you did write down a question, do you want to hold it up and Judy can come and grab that from you? So while she's doing that, let me start by asking a question. So this is kind of a value statement question, a little subjective, but you know, the individual exchanges, so you know, a lot of the talk about the exchanges are the shop exchange, which is the employer exchange, and then you have the individual exchange, which is for folks who don't have coverage through their employer. And that one is a little bit easier to understand the value. It's the only place, if you're at less than 400% of federal poverty, not eligible for employer coverage, that where you can get a subsidy. So it makes sense as to why there's going to be a draw for people to go there. But as you've been looking at this, talking to your clients, what's the value for an employer to opt to purchase coverage on a shop exchange versus just to continue to purchase it as they do today?
Sure, I'll start. I mean, I think the big thing that people talk about is the defined contribution and the ability to have some flexibility with the products that they're purchasing. That's what I've heard from employers. So, and then I suppose also knowing that, I mean, I think there's some certainty in knowing that buying a plan on the exchange, at least depending on the way the market rules go into effect this year. That could provide you some certainty in terms of the type of product you're purchasing. It's been approved already by the board and those sorts of things.
So can you?
Employees like that too. They like the flexibility, which is kind of the conundrum because the employers are going to want to get the tax deduction, right, and not lose that by doing the defined contribution.
Yeah. And it will be interesting, right, because there are carriers and large broker firms, and Hewitt, Mercer have announced that they're putting together private exchanges too. So it'll be there appears to be that interest from the private market for the defined contribution interest to fill that. Can you talk? I don't think you hit on just a little bit for folks to understand the little known, certainly little utilized, is the premium tax credit that exists for employers, which in 2014 they can only get if they go into the exchange. Is that something you could maybe just outline for some folks how that works?
For employers?
For the employers, yeah.
I don't know that I'm that familiar with employers' premium tax credit.
Okay.
I mean, for small employers.
For small employers under X number of employees, the average income has to be less than $50,000.
A certain number of employees under $50,000 on an average, and then a certain number of employees, obviously, and you'd be able to get a tax credit to purchase insurance on the exchange. What I've heard is that not a lot of employers are qualified for that tax credit. So I actually haven't heard very much about that.
So that's you're a small employer plus it's low wage employers. Yeah, I know that exists. I don't know much more than that about it.
Have a question, David? Do you want to go ahead and?
Sure. This says that in a firm with 1,030 employees.
You're over 50.
You're over 50. And one disgruntled employee threatens to get coverage through the exchange. will the company need to pay the $2,000 penalty times 1,000 employees? That is a $2 million penalty. Let's go back to the math.
Yeah, well, then you're already providing the coverage, right? So the 2,000 is if you don't provide the coverage, then you have those penalties, and you deduct the first 30, and then you pay the penalties on everybody else. But you're going to be a large employer. You're already going to be providing coverage, so that 2,000 penalty doesn't kick in. So the only penalty you could potentially have is if it's found not to be affordable, where if there's any percentage of the workforce that's paying above that 9.5% for their coverage, then it would not be affordable. And then there's the $3,000 penalty, but that only applies for those particular employees, not everybody.
Okay, did we have a... Bill, you seem like you didn't want to write your question down. Go ahead.
First of all, thank you both very, very much for the courage to stand up and tell us about this incredible plan. And as many in the room know, I was honored to have Governor Plunky when we had 16 members to study this in 2010. So not only some of the things that you covered here are certainly of great concern, but indeed, as a provider, there are even more onerous provisions in the law that we're going to have to try to figure and navigate. What I'm fascinated by is a business that my wife and I own that's principally part-time employees, and your calculation, which I appreciate, and we've looked at, that if we have a large number of part-time employees that by calculation equal a certain number of full-time employees and therefore exceed the 50, which of the 125 part-time employees, which ones get the benefits? Because the calculation that we made is that we will possibly exceed the 50 by calculating we have more part-timers, just by nature of the way we employ, than we would full-timers. And so if we count them all up and do the multiplication, we come up with your equation. For instance, as you said, if you have 40 part-timers, that's equivalent to 5 part-timers.
Right.
Right. So if we take all of ours and we come up, we've got 54. Which of the 160 get the 54 benefits? It's not the word for out. It's not. Do we divide it to all?
I think it's...
You're obligated to do what else your plan,
Yeah.
but only the ones that work 30 hours or more then would get covered. So the equivalency gets you to the point where you have to offer coverage, and then the next step is any of these employees working or reasonably expected to work 30 hours or more, but then
Have to have benefits.
correct.
That they don't have now.
Thank you for helping me on that. I think that's right. And
So it's a nightmare.
I think that if I'm...
It's you. Who are you going to pass the cost on? Yeah. Because they already have benefits from their spouse. So they're working a part-time job just because they like the part-time job. But now because of this, that decision by them to do that because they have benefits somewhere else, does having benefits somewhere else eliminate them from us having to pay for their benefits in duplication?
They would be eligible, but they could still waive. They're still going to have to pay a portion of the premium.
But we'd have to get the whole group together to decide how they're going to do all that, right?
So I think maybe just because I'm not sure everybody can hear the exchange here, I think that the question that Bill laid out is if you have an equivalent of over 50 employees, but they're all part-time, do you have to provide, who do you have to provide the benefits to? And I think what I heard was that you only would then have to provide benefits to people who work over the threshold of the hours. So if if everybody works less than 29 hours, you don't actually have to provide coverage to anybody. Is that correct?
That's my understanding is it's the full-time employees who get the coverage.
So part-timers are used in the calculation of do you have more than 50 employees, but under no circumstance are you required to offer benefits to people part-time. So I think we have time for one more question. Did anybody else write down a note? Does anybody else have a quick question? Okay, then. Can you please join me in thanking you very much, Dave and Susan, for being here today. Also want to thank all of our sponsors for being here as well. And don't forget to reserve your seat for the May 23rd Small Business Awards Luncheon right here at the Doubletree Hotel by Hilton, where we will announce our 2013 Entrepreneur and Emerging, who will be amazing, I'm sure, Entrepreneur of the Year. So see you all at our legislative session wrap-up breakfast next month. Have a great weekend, everybody.
The other issue is the